Good afternoon, everyone. Apologies for the technical difficulties. This is our first webinar where we're trying out using a sign language interpreter, so please bear with us.
Can I start? Can I start?
Yes.
Oh, okay.
I am Sibonga Ngokodo, a Wildlife and Triad Project Officer at the Endangered Wildlife Trust. Would like to thank you guys for joining us this afternoon for our discussion on the National Environmental Management Biodiversity Bill. By way of introduction, the Endangered Wildlife Trust is a conservation organization that was established in 1973. As a registered non-profit organization, our mission is to conserve threatened species and ecosystems in Southern Africa for the benefit of all. This webinar series is an initiative of our Wildlife and Law project and is centered around our Laws website. The Laws website is a platform that the EWT has specially designed to provide accessible and up-to-date information on environmental law in all of the South African official languages. Today, we are joined by Ngosi Vile, a sign language interpreter. This is to ensure that all our webinars are inclusive of all South Africans who use sign language as their home language. This is an initiative under our broader Laws website and is made possible through the generous funding from the British High Commission, the Embassy of Finland, as well as the Lewis Foundation. On our panel this afternoon, we are joined by my colleague, Ashleigh Dore, Nina Braude of the Biodiversity Law Centre, as well as Kate Handley of the Biodiversity Law Centre. Over to you, Ashleigh. You may provide a brief introduction.
Thank you very much, Sibonga. As was noted, my name is Ashleigh Dore, and I'm a project manager at the Endangered Wildlife Trust.
Oh, sorry. Nina, if you may kindly take a moment just to introduce yourself and tell us a little bit more about the Biodiversity Law Centre. Thanks.
Thank you so much, and thank you so much for having us both. I'm Nina Braude. I'm a senior attorney at the Biodiversity Law Centre. Kate Handley is our executive director, and we are a law clinic that was established in 2021, partly by Kate, to promote the interests of biodiversity and to ensure the thriving of biodiversity, everything that it makes up, and also ensure that people's livelihoods thrive within that very complex matrix that we'll be talking about today. I'm not sure if Kate wants to say anything further or wave or say good evening or afternoon, but it's a great pleasure to be here this afternoon. It feels like evening, sorry.
Okay, I take it Kate isn't going to add anything else. Okay, no, perfect. Just before we begin, we would like to encourage you guys to please use the Q&A tool and write your questions out throughout the webinar, and then we'll address the questions at the end once we open the floor up to questions. We're also encouraging you guys to raise your hands if you guys would like to present your question to the floor, and yeah, we're open to accommodating both sets. As a start off, Ashleigh, could you please explain to us what the current biodiversity laws are and what this bill seeks to do?
Oh, thanks, Sibonga. So essentially, South Africa has what we regard to be quite a complicated biodiversity legislative framework. And the reason for that is because of the concurrent mandate that's created in Schedule 4 of our Constitution. That gives a legislative power both to the national government and to the 9 provincial conservation authorities to create legislation among a range of environmental matters, but specifically for our purposes, biodiversity. What that's resulted in is quite a complex and sometimes contradictory legal framework, and is one of the reasons why South Africans that are involved in the biodiversity space feel overregulated. And we've participated in the department's roadshow on the bill, and overregulation was cited as one of the first challenges, one of the big challenges that this bill is seeking to address. Now, we don't believe that overregulation or the challenge of overregulation sits within our legislation, at least not national legislation. We believe it sits with the implementation processes, the permitting system that we have being largely paper-based and quite slow, and also the siloed approach that we have to biodiversity management across the country, where, for example, if you're moving wildlife from Limpopo to Gauteng, you would need upwards of 4 to 5 permits for that process. So that's where we feel that the challenges of overregulation come from. And one of the challenges with the bill that we'll speak to later is that instead of proactively addressing these implementation challenges, the bill has largely removed the requirements for permits altogether. And we believe permitting, if done properly, is a very effective way to ensure one, adaptive management, but two, to provide an effective foundation for compliance monitoring and enforcement where there are compliance breaches. So this is one of the challenges that we'll be discussing later on through this webinar in relation to the bill. What NEMBA does do currently, and sorry for my acronym speech, NEMBA is the National Environmental Management Biodiversity Act. It's a specific environmental management act, so must be read with our National Environmental Management Act and applied with that legislation. And it's the primary biodiversity legislation that exists in South Africa at a national level. It provides us with the authority to apply international conventions at a domestic level. And what it does from a regulatory perspective for species is it creates a general rule that if you're conducting specific activities with specimens of listed species, you require a permit. And then the permitting process is fleshed out in regulations, either the threatened or protected species regulations or the alien and invasive species regulations. What the EWT has been doing to strengthen decision-making relating to permits is we developed a permitting training course and are working constructively with government officials to strengthen effective and responsible decision-making in this regard. So I think that's a broad overview of the bill and the legislation currently and some of the challenges that are presented that the bill is seeking to address. And what we'll be able to show through this webinar is largely the challenges that have been raised. We don't feel the bill actually adequately addresses, and in fact, it weakens the regulatory approach and doesn't provide, in our view, for an adaptive or responsive regulatory approach.
Thank you, Ashleigh. Nina, would you have anything to add?
No, I think we'll get into it once we've outlined the bill.
All right, great. Okay, back to you, Nina. Can you provide perhaps a broad overview of the bill, how it's structured?
Thank you. So, like many pieces of legislation, it's organized in chapters and then in sections and sometimes in parts. And I'm going to refer to the chapters, the chapter numbers and headings, because I think that's probably what Ashleigh and I will be referring to as we progress through this webinar. So Chapter 1, like most pieces of legislation, deals with interpretation, objectives, and application. In there are some nitty-gritty things that we have as lawyers who engage with the intersection between international and domestic law as well as constitutional law flagged. But in a nutshell, very importantly, the state's trusteeship of biodiversity is maintained. The language has changed a little bit, but that's one of those nitty-gritty things. The objectives of the Act are contained in this chapter. The people and the place, the people to whom it applies and where it applies is contained in this chapter. And it also deals with the intersection with the National Environmental Management Act, which is the major framework legislation that Ashleigh has already mentioned, as well as how this interacts with other pieces of legislation. Chapter 2 deals with the powers and functions and institutional organization of the South African National Biodiversity Institute. It is largely a replication of the existing provisions in NEMBA, so existing legislation. There have been some amendments made, and we understand from the roadshow that the department had over the last week that these are largely to align with what is actually happening within SANBI. One of the things that has changed is that previously the chapter dealing with SANBI contained its powers and functions over the National Botanical Gardens. These have now been moved into Chapter 3, which deals with National Botanical Gardens and National Zoological Gardens. We understand that the inclusion of the national zoos is really to accommodate the Pretoria, the National Zoo in Pretoria, although the Biodiversity Law Centre has a couple of concerns about how the provisions relating to the National Zoological Gardens have been included in the bill. Then the next chapters are where things start getting really interesting, and I'm sure this is where Ashleigh and I are going to make many of our comments. Chapter 4 addresses biodiversity planning. It both is and is not the same as what we have now, and the differences create some very strange circularities and a few implementation challenges. Chapter 5 deals with ecosystems and species, and this is where the primary changes to the listing and permitting system start being seen. That particular chapter is divided into a very general set of provisions dealing with the ecosystems and species themselves, followed by information about the scientific authority, which is the mandatory body that we have under CITES, which is the chief convention dealing with trade in wildlife. And then there is a final provision there that deals with trade in species, and that may be something that we also want to touch on in terms of what it is doing and why it is there. Chapter 6 deals with alien and invasive species as well as genetically modified organisms, and this is the other chapter where we see major changes and again quite confusing implementation consequences. Chapter 7 deals with access to Indigenous biological resources and Indigenous knowledge by prospecting and benefit sharing. From the perspective of the Biodiversity Law Centre, this is one of the big successes of the bill. South Africa is signatory to the Convention on Biological Diversity and its protocols, including the Nagoya Protocol, which deals with access and benefit sharing, as well as, in other words, how Indigenous plants and animals can be used. And this is a success in terms of updating our legislation to conform with some of our international obligations, noting that NEMBA was promulgated and went through Parliament before the Nagoya Protocol was concluded. Then Chapter 8 is again a very important chapter. This is where our concerns about implementation really come to a head, and it deals with the issuing of permits and emergency interventions. Again, from the Biodiversity Law Centre's perspective, the provisions relating to emergency interventions are potentially positive, but the permitting provisions lead to a great deal of confusion and unnecessary complexity. And then finally is Chapter 9, which is entitled General and Miscellaneous, and this is a chapter that really must not be ignored because it contains a huge amount of detail and some very, very important provisions. I'm going to run through a couple of them quickly because these are things that many of them need quite a lot of thought and may lead us down some roads that are new. The first is what appears to be an innovation of biodiversity officers. These are intended to be members of the public who can be appointed. However, we're not quite sure who these individuals are meant to be or what their functions are supposed to be either, but there is potential. There is a provision relating to recognition of associations and organizations in the context of biodiversity. Again, some questions remain there. There was always the power for the minister to issue norms and standards. This has now been moved into this chapter, along with the public participation clause, which in our view has been significantly watered down and very problematically so. And then the big ones, I'm skipping a couple, but they're long lists of regulations in a regulation provision, and that is really where the nitty-gritty of this bill is going to lie, together with offences, penalties, and savings. And I would add that something that one always sees at the end of a bill is a section that deals with the repeal of legislation. And normally this is something that as a lawyer one tends to jump over a little bit. But in this occasion, it not only seeks to repeal NEMBA, but it also seeks to repeal a rather obscure piece of legislation called the Seals and Seabirds Act. And one of the things that it does not address is that there are still policies and extant regulations under the Seals and Seabirds Act. And there's no indication of how those are going to continue until replaced. So this is a bill that requires a fair bit of scrutiny. But hopefully that shape will help us with our discussion. Thank you.
Thank you very much, Nina, for that overview. Ashleigh, is there anything that you'd like to add to that?
No, I think Nina provided a very comprehensive overview.
Perfect. Ashleigh, could you please talk us through the new provisions or approaches in the bill that should be regarded as encouraging?
Absolutely. And maybe just a note for our participants online that the EWT will be sharing our comments on our laws website. I have included a link to the website in the chat. Our comments will be shared tomorrow morning as the public participation process is winding to an end. And for people who are interested in submitting comments, I think it is important to note that the public participation process formally ends tomorrow, I was assume at midnight. So if you are interested in submitting comments, please do. And I think, Jean, that automatically addresses your comment on clarity. We have confirmed that it is the 25th. Not the 26th. There was a duplication or a conflict of the dates provided. So some of the benefits or beneficial provisions or provisions that we regard should be encouraged. The first is that the NEMBA bill creates a duty of care. And while we regard this as something that should be supported, what we have noted in our comments is that it doesn't really go far enough. There was a bit of a missed opportunity around this duty of care. So colleagues that are familiar with other specific environmental management acts and our framework act, NEMA, would be familiar with the broad duties of care that are created within those acts, specifically the National Water Act and Section 28 of NEMA. And what we found here is there could have been an opportunity that should have been used to create a dedicated duty of care for biodiversity. Along the same lines as those other duties of care. So we've supported the establishment of a duty of care, but question why it wasn't created as a specific provision, like other examples that I've given. The second is the expansion of regulation to species that are regarded as not being threatened or protected. And we recognize, and we've raised this in our comments as well, that Section 41 can be strengthened in terms of clarity, but the spirit and purpose about providing regulation for specific species that are not currently threatened or in need of protection is very important when we look at it through the lens of human-wildlife conflict. There are a range of species that are in conflict with people and agricultural businesses and processes that currently fall outside the scope of regulation in terms of our threatened or protected species regulations, as well as provincial laws. So that's something that we support, although we have called for greater clarity within those provisions. And then the final one is the introduction of provisions that relate to wildlife trafficking. There's a new definition of wildlife trafficking included, and then specific provisions that have been included within the bill that seek to respond to wildlife trafficking. And this is very important in the context of South Africa, where not all wildlife crimes are motivated by organized crime, either at the local, national, or international levels. And that adaptivity or responsiveness within the bill is something that we encourage. Nina, I don't know if there's any other benefits or favourable opportunities that you've identified that should maybe be highlighted.
Thank you. I think, as I've already mentioned, the alignment of Chapter 7
Yes.
And the bioprospecting provisions with Nagoya is excellent in our view. We also have identified more or less the same themes that you have, and something we would add in terms of the duty of care is the recognition or the attempt to recognize animal well-being, which in our view is long overdue. It is also something that flows from the white paper on conservation and sustainable use of biodiversity, and also gives effect to a number of judicial decisions over the last couple of years, recognizing animal sentience and the relationship particularly between animal well-being, human well-being, and cultural, spiritual, and traditional rights and knowledge. So again, we have some questions about how well this is done. We have some questions. I see there is a comment about definitions. We do have some questions about that, but we think that this is a turn in the right direction.
Perfect. Sibonga, that's all from me for right now. I think that we can move into the next point.
Perfect. Thank you both for that. Nina, could you please talk us through the new provisions or approaches in the bill that you seem concerning or should be regarded as concerning overall?
So I would start by saying that we have approached this from the lens of, does this conform with Section 24B of the Constitution? So a lot of our concerns are they're premised on constitutional law and principles, and I'm not going to go into all of those in detail because there are a number. But essentially what has happened is that in identifying complexity and difficulties with implementation, what the DFFE has seemed to have done is to try and create, or they've stated that they've tried to create the Biodiversity Bill as framework legislation, bearing in mind that this now sits within an existing framework of the National Environmental Management Act. So that already creates a little bit of confusion, sort of Russian doll effect of having to go through layers to find out what you have to do. And the main consequence of this is that all the detail is left to regulation, much of which is at the discretion of the minister to put out. And this is coupled with weakened public participation provisions around regulating. So all of that causes a massive concern in terms of whether this particular bill actually adheres to principles about separation of powers between the Parliament and the minister and the administration. It also raises questions about the degree of certainty or vagueness in the bill, which the law requires the laws to be reasonably certain, so we all know what we're supposed to be doing. And the removal of clear obligations in terms of prevention of harms to biodiversity and promotion of conservation are of extreme concern. Where we see those concerns materializing is in the combination of the species and ecosystems chapter, the alien and invasive species chapter, the permitting chapter, and the regulations. So you have to read all of that together. And once you do, what we see is very generic statements that the minister may publish lists of species that are threatened or that threaten our species and ecosystems, and ecosystems that are threatened. And then slotted in there, we see the expanded set of species that can be listed, as Ashleigh has already mentioned, either requiring heightened protection because they are under threat, or because there is a relationship between those species or ecosystems and cultural rights, or because there is a heightened need to attend to the well-being of particular animals. And then it is left to regulation to come up with individual sets of conditions and prohibitions and anything else that relates to these species. And when we've been trying to work out how in practice this is going to work, we have struggled to make it a system that can actually find any kind of implementation other than on a species by species basis, which, if anyone can imagine that, is entirely unworkable and will only add to the confusion and the administrative burden that is actually one of the things that's trying to be solved. So those are our most critical issues here. And our solution in terms of what we have put in our comments is at the end of the white paper, there is a chapter that deals with implementation of this policy. And it contemplates a public participation consultative process to analyze the full range of existing legislation and identify gaps, and then, if necessary, to move forward with legislative amendment. So we have requested that the department make its list of implementation challenges public, and that it kickstarts this implementation plan, and then hopefully the public, with public input, they can put together amendments or a new bill if that is what emerges from such consultations. So that is the big picture. And I think, like EWT, we will be making our comments available on our website, and you can read many of our concerns in those once we put them up. So that's me for now. And Ashleigh, I'm sure there are things you would want to add.
Thanks, Nina. I mean, I think you've touched on the really big things from a permitting perspective. And while if we look at it through a legal lens, it creates legal uncertainty and operational challenges from a legal perspective, we also are struggling to understand how South Africans will navigate what is going to become fundamentally a more complex legal framework. Already with the general rules that are provided within NEMBA, people are unaware of their permit obligations. Now we may have upwards of 4 different lists, or 5 different lists if we use the other provisions in section 41 and 42. And it's left to the average South African to try and navigate what permits are required where. And then again, recognizing that lack of knowledge of unlawfulness is not a criminal defense, we feel that the burden that this is placing on people from a compliance and enforcement perspective is quite unfair, and really is not going to enhance compliance with the law when you've created this very complex field of lists and regulations and legislation to try and navigate. So we've critiqued that in quite a lot of detail in our comments. And the other challenge that we have with the bill is that it doesn't proactively address the conflict between provincial and national legislation. In fact, it removes the guiding tool that one would use, which is section 146 of the Constitution. And we did raise this in the public participation process, and we're told that it's moot to cross-refer to that legislation. But again, it assumes knowledge of the full realm of legislation that South Africa has for citizens to then go and read very detailed provisions of the Constitution to try and get clarity on how they're supposed to resolve conflicts. So again, we felt that weakening of the conflict provisions in Section 5 places an unfair burden on South Africans, but it also doesn't address the 9+1 challenge that I mentioned in the beginning of this webinar. And here, what we're saying is, don't just respond to conflict, but create an enabling framework that calls for a holistic and rationalization process for our legislation, and try and address that concurrent mandate in a way that South Africa has a body of law that effectively regulates species and ecosystems at provincial level and national level, and not the current duplication and conflict that we have. And just as a plug for additional work that we're doing within the space, we will be publishing a report on the state of provincial law in the country. And there, I think people will see the full nature of how complex this framework is, but also the conflicts that exist within the framework. And then the final concern that we have is the exemption provision. And that's one of the sections that Nina mentioned that sits under the miscellaneous chapter. And what that exemption provision allows for is the minister to grant exemptions without going through a formal process that can just be in writing with the exempted party. And we have fundamental concerns about transparency within that process. So those are the big concerns. I think overall, our position is that this bill doesn't advance biodiversity legislation. In actual fact, it weakens it. And that we have called for a substantial revision of the bill, but better if we are going to completely repeal and replace our legislation, that consultative process really needs to be done properly and not the kind of ad hoc way that it seems to have been done with this bill. Thanks, Debo.
Thank you both, Ashleigh and Nina. Do you guys have any comments that you guys would like to raise before we step into the questions and answers part of the webinar?
I've got one, which I feel is a bit of a missed opportunity within the bill, and that would be to expand the principles that guide decision making. So for colleagues online, if you take a look at Section 2 of the National Environmental Management Act, it sets out principles that apply to all decisions affecting the environment, regardless of the department taking the decision, and sets out a very proactive approach to what are the foundational requirements that need to be considered. Now, it's not perfect in its implementation, and there's many instances where they're not applied. We're currently litigating around a water use license that's been granted that's failed to consider the principles. But with those implementation challenges aside, what we regard as quite a missed opportunity within this bill is to set down specific principles for biodiversity, conservation, and ecologically sustainable use, and really proactively guide what should be considered when government departments are making decisions or policies or regulations relating to our wildlife and our wild spaces. So that we felt was a bit of a missed opportunity to, in addition to the duty of care and the missed opportunity there to create a dedicated duty of care.
Thanks, Ashleigh. Anything from you, Nina?
Thanks. Yes, I think we've also identified a couple of missed opportunities, and some have been drawn to our attention. And one of the things that has struck us is that there is quite a lot in the white paper that is really innovative in terms of moving away from so-called fortress conservation to living landscapes and seascapes approach, and we do not see that concept developed in the structure of the bill. It does not move away from a command and control approach. It still has these quite onerous recourse to penalties and offences and that kind of thing. So there is some reference in the planning section of the bill that alludes to some of the relevant concepts, but this is really underdeveloped and a missed opportunity. And there are two others that have been drawn to our attention. The one is relating to the absence of target setting that is specifically provided for in the bill. And some of you may or may not be familiar with the UK Environment Act and the way they address targets, which are currently slightly controversial. But in thinking about this, we've looked at the planning chapter and the way in which the National Biodiversity Framework has been reproduced very much as it has been done all along, without any intersection with our various reporting obligations at international level, our various targets, including under the GBF, which flows from the Convention on Biodiversity, in which we're going to have our first reporting obligation at the end of this year. So that was another. And then the third is, and coming back to actually the Water Act and transparency, it is pointed out to us that there is a serious missed opportunity here in terms of requiring the publication of permits. And this is particularly important given that many of them don't go through the sort of very stringent process of water use licenses, mining rights, environmental authorizations, and those, and under the Water Act, although some of those are supposed to be made public, we still have issues with those. And there has been case law around this in the biodiversity space. So yeah, those are also missed opportunities, and it would be great to see some development in those areas. Thanks.
Thank you so much, Nina.
I think, sorry, and it was just, you flagged a thought, but in addition to not setting targets, what the bill's actually done is removed any timeframes for review as well. And that's something we've also critiqued, is we believe very strongly that if we are to have adaptive management, we need up-to-date information. And if colleagues look specifically at the planning tools that are provided for in Chapter 4, all of the timeframes for review and revision have been removed, which we find particularly concerning.
Thank you, Ashleigh. Thank you both for giving us more insight into what the bill entails. We'll now be moving into our questions and answers section of the webinar, where we'll open the floor to questions, and we encourage you all to use the questions and answers tool, as well as present your answers by way of raising your hands.
So, Siba, I see Jean has used the chat
Yeah.
for a few points. The first is raising a concern about the definition of biodiversity that doesn't extend to the definition of biodiversity. Let me just go over there. Well, there's no actual definition of biodiversity. Oh, there it is. Sorry, my apologies. What happens when one tries to think, read, and talk at the same time? So Jean's concern is that the definition of biodiversity does not extend the duty of care to individual animals, should the word specimen not be added to genetic species and ecosystems. So just to confirm what the definition of biodiversity is within the bill, it means the variability among living organisms from all sources, including terrestrial, marine, and other aquatic ecosystems, and the ecological complexes of which they are a part, and includes diversity at genetic species and ecosystem levels. So, Jean, I'm not particularly concerned that there's not the cross-reference to the duty of care in the definition of biodiversity. And Nina, I don't know if you take perhaps a different approach. What we are concerned about is that the provisions that exist currently for well-being to be integrated into ecologically sustainable use decision-making processes and regulations that really consider the individual animal as part of broader decisions have been weakened in replace of taking a duty of care approach. And we wholeheartedly support taking a duty of care approach, but it should be in addition to well-being and not as an either-or, because the way a duty of care is framed and the definition that's provided in the bill says the reasonable measures to prevent harm to biodiversity, and when those harms cannot reasonably be avoided or stopped or minimized and remedied, that looks at things at a system level, where well-being requires the individual animal to be considered in system-based decisions. So that is a specific concern that we have, is the weakening of well-being. And this is something that we've seen come through in the process of the white paper as well. At the public participation process, the definition of sustainable use was provided with a specific reference to well-being of individual animals, and that got replaced when it was finally published with this duty of care. And they're two different things, and they should not be conflated in our views. Nina, I don't know if you take a different approach.
Overlapping.
Right.
So the definition of biodiversity reflects the same definition as in the Convention on Biological Diversity, except that there's a small change at the end. So they've put genetic species and ecosystem levels in place of what the Convention says, which is within species, between species, and of ecosystems. We have absolutely no idea why there's a change, but substantively it probably means the same thing. In terms of the concern about specimen, the way in which the definitions work, that probably isn't such a problem in terms of statutory interpretation. In terms of duty and care and well-being, I entirely agree with what Ashleigh is saying in relation to what the bill does by conflating the two. In terms of our comments, we have suggested that the definition of duty of care is aligned with the language of duty of care in Section 28 of the National Environmental Management Act, except that it applies specifically to biodiversity, because just from a statutory interpretation perspective, that would make life a lot easier. There are rules about reading things in the same space to mean the same thing. So that would save everybody potentially a lot of time, trouble, and court cases. And then in terms of well-being, something that we like is that the definition included in the bill refers to both individual animals and populations of animals. And we think that is very useful because that is potentially a bridge between the individual physical and mental well-being, how they interact with in their own communities, and I use that very loosely, thinking of communities of microbes, and also within their sort of broader ecological systems. So we wouldn't want to lose that, and that is something that we would like to see pulled through the remainder of the bill.
Perfect. And then in relation to domestication, a comment was made that it seems problematic since it could just be behavioral change. I think, I suppose I take the point. The provisions around domestication specifically empower the minister to make regulations that prevent domestication, which we would regard as very encouraging, specifically as it's linked to the litigation that the EWT went through to challenge the inclusion of wild animals in the Animal Improvement Act, for example. So we would regard any legislative tools that seek to prevent domestication of wild animals as something that should be supported. So Lara has raised, do the changes impact biodiversity management plans? The short answer is the detail that's provided for BMPs has been weakened, as well as the review and amendment processes that they should go through. So the short answer to that is yes. But Nina, I know you guys have been thinking a lot about the planning framework. I don't know if you want to take the opportunity to engage more on that.
So one of the big changes with the biodiversity management plans is individuals and organizations outside of the minister and MEC can no longer introduce them, which we see as a big weakness because a lot of the practical work of BMPs is done by NGOs in particular, as well as academic scientists and other organizations outside of government. In looking at the three major planning tools, and there are biodiversity agreements contemplated in the bill, sorry. The three major tools are the National Biodiversity Framework, which is more or less what we have at the moment, although again, we think it can be improved. And then there are biodiversity management plans and spatial biodiversity plans. There is potential for all of this to be structured in a way that would properly allow us to mainstream biodiversity throughout all planning instruments across all areas of governance. And we see this as one of the big missed opportunities. What we are proposing is that there is a system where biodiversity management plans have to feed in to spatial biodiversity planning, that spatial biodiversity planning should be based on the CBA or critical biodiversity area mapping tools, and that those should be mandatory as inputs into all the other planning tools that exist, including municipal planning tools, agricultural planning tools, and so on and so forth. There is a policy basis for doing this that sits in policy from the Department of Agriculture. It recognizes the importance of drawing these connections. And we think that there could be smart ways of redrafting and reorganizing Chapter 4 so that this is achieved. But at the moment, just in terms of the narrower question being asked here, probably there aren't changes to BMPs other than the express ability of non-government actors to introduce them. So that is, yeah, and this is where our difficulties, and I think EWT's difficulties, lie in terms of the vagueness of the provisions. Something I just want to pick up on in terms of the comment about domestication. We also haven't really addressed it from that perspective, but what we have observed is that, as Ashleigh has been speaking about the plethora of provincial legislation, we have also looked at the disconnect between the biodiversity legislation and the animal welfare legislation. And I alluded to some of the judicial pronouncements about animal sentience and animal well-being, and those have been directly connected with biodiversity and how it is understood in our constitutional framework and in our country. So there is also a problem there in terms of how we treat welfare in one set of legislative enactments and how we treat well-being and the duty of care here.
Maybe to tag onto that, I mean, I see Louise has raised that, well, the well-being definition misses the quality of death. I'd always understood that when one, death is a part of life, so where your provisions consider the full scope of life, it should consider death as well. And that's a position that's been taken with welfare, but it is kind of worth reconsidering whether specific reference needs to be to end of life processes as well. And Audrey has raised the support for the reference of ecological sustainable use, and this is certainly a trumpet that the EWT blows on regularly. What the Constitution requires in Section 24B is that the environment be protected. That's the constitutional mandate, and that it must be protected for present and future generations through reasonable legislative and other measures that, among other things, ensure ecologically sustainable use while promoting, I think it's justifiable economic and socio development. So this is something that we raise regularly, and very much with ecologically sustainable use is taking a systems approach to sustainability. So we have cross-reference to the relevant findings of the high-level panel of experts that were looking into management and legislation processes for elephant, rhino, lion, and leopard. And we have cross-reference to those provisions that specifically call for that systems approach to sustainability and use wording and terminology that is reflective of ecological sustainable use. Another challenge that we've also raised, or critique that we've raised, is sustainable use is incorporated in the definition of conservation in the bill. And we've critiqued that, in our view, they're two separate processes. They can be mutually reinforcing, and there are many examples in South Africa where they are, but they're two separate processes and they shouldn't be conflated into one term. So we have critiqued that and proposed an alternative definition for conservation. Then Jean raised the lack of wildlife welfare in agricultural legislation, and the attempt to domesticate wildlife needs to be safeguarded against in biodiversity legislation. And we completely agree. And that's why we feel one of those missed opportunities is setting principles that require other government departments to take into account when they're making decisions relating to biodiversity, including wildlife. So we thought that by creating principles, you've come up with a very constructive and proactive solution to conflicts between various government departments. I see we've got 5 minutes left of the webinar, and I am mindful that our colleagues from the Biodiversity Law Centre have to step off just before 5 o'clock. So we could potentially take one more question, and I see one's come through from Sinasiso to say, does the bill contain any more comprehensive regulatory mechanisms to guarantee compliance and efficient enforcement and any harsher penalties proposed? It does in relation to wildlife trafficking. It does empower stronger sentences. And we've not objected to that, and we actually think that it's important that legislation creates various penalty provisions. What we have critiqued is the lack of incentives for compliance in the bill. It's really silent on it, except empowering the minister to create regulations to incentivize compliance. And we also, what we have done is cross-reference to the research of Edwin Cameron, who's confirmed that harsh penalties or strong sentences in and of themselves do not create a deterrence. What you need is an effective prosecutorial process and convictions. So they must be coupled with a certainty of conviction. The provision itself doesn't deter people. And that's been confirmed in a wide range of literature. So yes, so we are seeing stronger penalties, but I think they must be read with that caveat. Nina, I don't know if you would like to add anything to that in closing.
I think something that we've picked up is that in the chapter dealing with species and ecosystems, there's a potential here for the minister to list species that require additional compliance and enforcement resources or require stricter penalty provisions. During the consultations that were held last week by the DFFE, an interesting point was made that in terms of priorities of other departments, such as the police, they're often the ones who carry the resources in order to run with a particular theme or priority. And they wanted this provision in here to allow the DFFE the flexibility to operate independently according to their own assessment of priority crime in particular. We think that this is something that needs to be considered very carefully. We do think it has potential. But one of the things that we have picked up is that there isn't actually anything in the regulation provisions that allows for the minister to actually regulate penalties. And also, there isn't anything there that limits the ability of the minister to impose penalties and to create offences. And that is problematic because in terms of the various powers of the legislature and the executive, the minister cannot create self-standing offences unless empowered to do so by Parliament. So this is an area that we think really does need to be developed, not dispensed with. Because and that is also, of course, subject to the problem with the lack of incentives. And we are as concerned as EWT at the evidence that harsher penalties are not necessarily the way forward. And I think that's really what I mean, if I were to have a closing statement, I would say, look, this has to go back to the department. This is not it hasn't even been introduced to Parliament yet. So now is the time to really think about what can work for us, what is going to actually give us ecologically sustainable use, what's going to secure the ecological sustainability of our biodiversity. And the word secure is actually the language in the Constitution. What is going to promote conservation, what is going to prevent ecological degradation. And all of this, we sort of need to think in terms of that constitutional override, that this is all to protect the environment for the benefit of the present and the future. So that is, we're in this for the long game. So I would certainly urge people to keep an eye and engage and let the department know your thoughts and your suggestions, and hopefully we can get somewhere that does solve the problems and works for us all.
Thank you, Nina. I mean, I think that's an excellent call to action, and one that we hope everybody on this call will take up. It's very important for people to exercise their voices and to raise what you support and what you find challenging and problematic. And hopefully our comments will be taken into consideration, and the bill will either be taken off in a fully participatory process undertaken to inform next steps, or substantially revised. Nkosibile, thank you so much for making our first webinar fully inclusive. We're very appreciative of you, and Sibonga Konke, well done on your first webinar. You chaired it fantastically. Colleagues, thank you very much.
Thanks everyone for joining in.
Thank you.
Thank you very much. Have a good evening.
You too.
And thank you, EWT, for organising.
Thanks, Nina. If there are any other remaining questions, you're welcome to reach out to us on our emails. I realize we didn't get to all of them.